As you have listened, reporting is a very important factor in sustainability, and it is not yet adequate. It is not covering all the sectors. It is not being really comprehensively covered and so on. You see, she pointed out quite a few areas. The wastage in water use. In the household, for example, the toilet is an area of great consumption of water. Even the flush system can be a major source of wastage. Have we ever thought of more efficient flush system to conserve water? Let us look at this consumption, the wastage pattern. How much wastage we create? How can I control them? The basis of all these is the reporting pattern. The key performance indicators that are needed must be developed, must be followed, and we must encourage all organizations, all households to be aware of these issues. Thank you, Ms. Raja Khadiyar, for your excellent presentation. I would now like to invite Dr. Harsha Cabral, President's Council, Sri Lanka. Mr. Cabral is a member of Law Commission of Sri Lanka. He is also a member of Advisory Commission on Company Law, member of the Ministerial Committee appointed to reform commercial arbitration, council member of the University of Colombo, UGC nominee for PGIM. He is also a member of the Council of Legal Education, member of the Corporate Governance Committee, seated member of Aquinas University College, member of the Board of Studies, School of Accounting and Bureau, member of the LIRP, that is Legal and Judicial Reform Project. In addition, he is also director of several companies, including chairman of Tokyo Cement Group, author of several books on company law and intellectual property law, senior lecturer and examiner of the University of Colombo, council member and faculty member, course director of ICLP. In addition, he is also vice president, BRIPASL. He served as senior counsel with 28 years experience, specializing in the fields of company law, intellectual property law, commercial arbitration, commercial law and international trade, and President's Counsel for 9 years. A person with a very checkered background. We would like to listen from him on corporate governance and ethics.
Good afternoon, ladies and gentlemen. Thank you very much for those kind words. Distinguished lady and the distinguished two gentlemen on the head table. Professor Lakshman Vatawala, distinguished invitees and delegates from several other countries, ladies and gentlemen.
Gentlemen, you will have 20 minutes maximum.
Yes. I'm sorry I don't have a PowerPoint presentation, but instead I have a paper. As council, we can't show films, so we have to sing for our supper, and that's how we make our living. So I'm sorry I don't have a PowerPoint, but I'll try and explain a few experiences we have. And the paper, please don't look at it now, because this is the napping time. You'll fall asleep if you start reading now. You can keep it for a better moment when you want to fall asleep. Now, the topic that is assigned to me is basically corporate governance and the role we have, especially in the Sri Lankan context. Now, let me say that the word corporate governance is not to be seen in most of the corporate statutes. Now, corporate governance is a new mechanism which came into being in the early 90s, like the mobile phone. Prior to that, we didn't have anything to do with corporate governance, but it came in a different way. With the Cadbury Commission in 1992, they started the term was used as corporate governance, and world over started talking about corporate governance, and even in Sri Lanka, we started way back in 97 to come up with our own codes, so on and so forth. Professor Waterwell was involved in the initial stages in the Institute of Chartered Accountants, and then we also have our own code of corporate governance, best practices, and what exactly is corporate governance is the issue. Now, if it is not found in the corporate statute as well, we all know that governance is a very, very common thing. Proper governance, correct governance, due governance, right? When Mr. Modi in India, President Sirisena in Sri Lanka, they talk about governance, the correct governance. In Sinhala we call it Yaha Palane, right? That's a way of proper governance, right? Now this governance is a very, very common term. When you govern someone, government, governor, governor general, these are all terms we were used to. But when it comes to companies, it's called corporate governance. Now the next question that is asked frequently is, why can't you bring corporate governance in the corporate statute itself? Now we have a new Companies Act number 7 of 2007, which came in quite recently, I must say. Now it has been there for almost 8 years. I was also involved in drafting that act. Now, if you look at the 534 sections in this act, nowhere would you find the word corporate governance. Now, for the corporate sector, especially for the listed companies, in a small way, corporate governance is included in the securities regime. The minimal interference of the statutory regime is seen under the securities regime, where it says if the company is listed, you must have independent directors, X amount of independent directors, the ratio is given, and also you must have your committees, the audit committees, the nomination committee, so on and so forth, all right, remuneration committee. Now the issue is, why can't you bring in corporate governance in a statutory form? Well, the beauty of corporate governance is something that comes from your heart, right? You can't force anyone. It's like the 10 Commandments or what Lord Buddha preached. We have the Dasasil, Atasil, Dhammapada, so on and so forth. You see? So where you may not be able to follow all 10 Commandments, but if you are able to follow at least 5, you are considered a good boy. So the issue is, how best can this corporate governance be brought into the corporate world? Now, as I told you earlier, the statutory interference is minimal. But when you think of the Companies Act, even in our act or various other acts in other parts of the world, you would see it has been brought in a different way. Now, in our own act, in section 184, it says that the company ought to be managed by a board of directors who would be appointed by the shareholders. Members or shareholders don't run companies. That's basic company law. They appoint a board of directors to run the companies. Now, then it goes on to say who a director is. In our act in 529, the definition of a director is given. And that's a very, very wide definition. Who is a director? And there you may not find the word alternate director, non-executive director, independent director. Those are not there in the statute. Those would be there in your corporate governance regime and also in your articles. You see? So you're considered a director. The definition of a director is there. All right? Who is a director on the form, registered with the Registrar General of Companies, and who falls under that particular definition of a director who exercises control over the company, and that is called board control. The board may consist of a couple of directors. Now, if the company is listed, the director's role becomes bigger because the public has put shares, like in banks and so many other organizations, where the role played by the board of directors would be very much important than the role played by a normal director in a family-oriented small private company. Now, in our provisions of the Companies Act, very specifically it is set out. I must say for the first time, we didn't have it in our old act. We have followed the British legal structure to a certain extent, and our earlier act was based on the 1948 English Statute, Companies Ordinance. But now the Companies Act number 17 of 1982, 7 of 2007 is a total deviation from the old English law. Because the old English law had certain strong principles. Now those principles are even in England not to be seen because of the EC directives that have come and taken over the legal system in England. But our current act is based more on the Canadian formula. We followed the New Zealand model, and the Canadian model, which is now treated as one of the best models in corporate law, is seen in our act. And in this act, for the first time, in black and white, it has been set out the role of a director, who a director is, what the board of directors should do. A couple of sections. In 186 it says, a director should act in the best interest of the company and act in good faith. Simple as that. Anyone would understand. Then the next section says, 187 says, he must follow the provisions of the Companies Act and the provisions of the Articles of Association. That again is no problem at all. Then the third one says, 188 says, you should not act in a negligent manner. The standard of care that is expected. Thereafter, there's a series of sections what the directors should do and not do. Conflict of interest in shares, conflict of interest in transactions, in contracts, so on and so forth. Now, these have been brought in for the simple reason that there is no major qualification required to be a director. Right? In most of the statutes all over the world, you find this basic thing where if you're above 18, if you're not a lunatic, if you're not a bankrupt, and so many things put out, you can be a director. Sometimes the knowledge or the fact of, say, whether you can read or write is also not a qualification to become a director. I believe in India also you have it, and in Sri Lanka also we have it. And that's like doing politics and becoming an MP, you see. You find even in our situation, we have a whole lot of people who are not qualified in such places. So same with companies. If the wrong people are appointed to boards by the shareholders, you would know what the outcome is. So because of that, the guidelines are given. This is how you should behave when you're on the board, right? And then that is supported by a thing called corporate governance, transparency in management, proper governance, due governance, so on and so forth. Now the issue is, how best can a director perform when he is on the board? That again will depend on the standard of care, how and what he should do. Now the old story was, well, when you are governing companies, if the company is making profits, well, that's no issue, then everyone is happy. You're paying dividends, your shareholders are happy, the company is doing fine. In the current day setup, it has changed. Over the years, it has changed to a certain extent. And now you say, not making profits alone is not the criteria. You go further. You've got to look after all your stakeholders. When you say all the stakeholders, your company, your shareholders, majority and minority both, then your creditors, lending institutions, your employees, customers, and now it has gone further with corporate social responsibility. It stretches even further to say, you've got to look after the world at large. Not only the stakeholders, but then to the world at large. So what then is the responsibility of the director? Right? How does he perform when he is on the board? Now all the checks and balances are there in the Act, but then to compensate that in addition, if it's a listed company, you have brought in this mechanism of corporate governance. Now the corporate governance mechanisms can come by way of the security regime, the code of good governance, the code of best practices. As in England, what they have introduced, all over the world, they have started introducing these mechanisms of corporate governance. We in Sri Lanka have spearheaded through the Institute of Chartered Accountants and the Securities Exchange Commission, and we keep on updating our code of best practice. Right now, if you go into our SEC website, you would see that a detailed code is there, what is available. But what is fundamentally important is you are not compelled to follow all that. Even a private company can follow it, but what is the compulsion is very, very limited. Still what we have is you must have your committees and your independent directors. What is independence, so on and so forth, is explained. But the main issue is how best are we following them? Right? What are the mechanisms to look after them? Now, in Sri Lanka, you might see we have another regime where the banking sector comes in. The bank supervision and non-bank supervision has gone even further. The directives that come from the Central Bank of Sri Lanka with regard to corporate governance directives are very, very stringent. Much stronger than the powers we have under the normal regime. So, in conclusion, I say that the corporate governance mechanisms in Sri Lanka are in place and proper, and we keep on improving them. And I would share a few moments with you, quoting one of the books I wrote on corporate governance, and in that I have set out a couple of golden tips for directors. I will quickly rush through them so that I can share some thoughts about the local regime on this issue. These are some valuable tips for any director. Be mindful of accepting directorships. Do not take over past sins of others. Do not join rogue clubs. Check the history of the company before joining the board. Act in the best interest of the company at all times. Always act in good faith where your bona fides can be established easily when in doubt. Never act in a reckless manner whilst on the board. Never act in a grossly negligent manner whilst on the board. Always rely on your experience and knowledge in business judgment. Do not let your personal interests conflict with the interests of the company. Familiarize yourself with the important provisions of the Companies Act, which can have an impact on your actions on the board. Familiarize yourself with the provisions of the Articles of Association of the company. Note that in the Companies Act, it is specifically stated that provisions set out therein are in addition to and not in derogation of any provisions contained in any other law relating to the duty or liability of directors or officers of a company. Ensure that all statutory obligations of the company, example EPF, ETF, taxes, etc., are complied with forthwith. Compliance check either monthly or quarterly. Ensure that all banks and other lending institutions are serviced accordingly. Compliance check either monthly or quarterly. Regularly check whether the risk management techniques of the company are in operation, enterprise risk, strategic risk, etc. Note the significance of several other important provisions of the Companies Act that deal with vis-a-vis the company name, company number, special provisions applicable to private company, the solvency test, distributions, stated capital, capital maintenance, reduction of stated capital, dividends, financial assistance by a company for acquisition, minority buyout rights, meetings, proceedings, major transactions, etc. Check whether the financial reporting is done in a professional manner under the provisions of the law. If the company is listed on the stock exchange, make sure that you are aware of the provisions of the Securities Exchange Commission Act and the SEC rules. If the company is listed on the stock exchange, make sure that you are aware of the provisions of the listing rules of the CSC. If the company is listed on stock exchange, make sure that you are aware of the mandatory code on corporate governance and also the voluntary code on corporate governance. Even if the company is not listed, try to follow the corporate governance mechanisms in place for good governance. Consider the mechanisms of CSR for company. If the company is a licensed company, make sure that specialized provisions of the Banking Act are followed. It goes on and so forth. And finally, we set out that if the company is a specialized entity, make sure that you are aware of the provisions of statute which have an impact. Be mindful of your actions that can be impeached by the company, directors, shareholders, creditors, and other stakeholders under the provisions of the Companies Act. Be mindful of oppression and mismanagement actions and derivative actions that can be instituted. If the company is a conglomerate or a group company, ensure that you have a fair knowledge of holding companies, subsidiary companies, associate companies, and the respective roles. Check whether the consolidated accounts or group accounts are done accordingly. Be mindful of related party transactions of the company. Ensure that all disclosures are made under the law. Use your conscience when taking decisions at board level. Make use of your own expertise when you have a superior knowledge on the subject. Never let others who are lesser knowledgeable on the subject matter issue pressurize you to change your decision. Always ensure that independent directors are truly independent. Always ensure that the board recognize the views of independent directors. Do not be under obligation to the chairman or any other member of the board. Have an independent mind of your own. Ensure that your dissent on any matter is recorded and check the board minutes, read the board minutes, see that, know the board minutes. If you're not an expert, ensure that you rely on third-party expertise. Remember to keep advice recorded. Beware of the provisions and see that the insurance covers are in place. Then you also said that check whether the subcommittees of the boards are in operation, check whether the company external auditor is performing rights, check whether the company secretary's role is doing, whether the SLS, IFRS rules are followed. Avoid being a mere passenger on the board, endorsing all decisions of the board in a passive manner. Be cautious when giving personal guarantees for corporate benefit. Remember that ignorance is no excuse. Remember that accepting a directorship is not joining a cocktail circuit. Never discuss boardroom matters with family members. Never discuss boardroom matters with friends or associates. Do not disseminate price-sensitive corporate information to any third party who is not entitled to know them. Do not trade your principles for money. Thank you very much.